You know, it was
Steve says
it's
that's
a
true.
load here. It's a
Steve says,
load here trying to keep that
"Oh, trying to hold
that
that
ball in
up."
the air here. But you know,
Yeah,
I'm getting too old.
I see. Steve says that's true every week, so he's defending my honor in that regard, unless he means himself, which I kind of doubt. But there is no.
I thought he was talking about you, Leslie.
No, he was clearly talking about you, my friend. Um,
Oh, that was sweet.
So, and Ship, I see you, and I'm gonna make you a speaker. Let's see if that works, because I've put Margot into co-host. I mean, you snooze, you lose, Shipster. Um, let's see if he can join as a speaker instead of a co-host. So, Margot, we probably have you for a limited time tonight. Is that right?
Yep, probably about an hour.
Oh, okay, great. So that's longer than I thought. That's fantastic. So rather than me launching into the litany of updates I was going to do, why don't we start with the case that I think you may be the most interested in? There's two of those. Um, the National Guard case, or I saw you tweeting about that, and also you've been following that Kilmar Abrego Garcia thing, and as Ship has as well. So, all right, Ship's a speaker now. Ship, can
Yeah.
you hear us? Okay, great. Can you hear Margot?
An hour? You're just going to do an hour? Nobody checks out of this thing after an hour.
Right.
You check out of this thing after an hour, you get demoted, and some guy named
Right.
Ron takes your place.
Exactly. If you can't go 3 straight hours with no bathroom breaks talking about the law, then what kind of lawyer even are you?
A retired one.
Yeah, that's what I think too. Yeah, that's what I think too.
Yeah.
Okay, you guys. Well, all right. So, shall we start with National Guard, or shall we start with? Well, yeah, let's do that one because it's cleaner, I think, than Kilmar's case is all over the place. Do you
And
guys?
I would like to, I'd like to throw out the Planned Parenthood one because that is actually the second one with the National Guard that I'm the most interested
Aha.
in.
Okay, Steve's interested in that one too, and you guys, he's here with me as well tonight. So, all right. When you guys, this is a little aside. Every time I see that Kilmar Abrego Garcia name, I always think of Kilgore was here. Like that just makes me think of that every time. I know that is random. And if you don't know what that is, you're probably under the age of 50, so go look it up. All right, you guys. So, Margot, I saw this first on your timeline, so I'm going to give you the hat tip to it. So, as we all know, in this National Guard case, the Ninth Circuit stayed the order of Judge Breyer in California to the Northern District, I think it is, of California, to say that Trump had improperly taken over the California National Guard. And that went up to the Ninth Circuit for a stay. The Ninth Circuit, a 3-judge panel, granted that stay on June 19th. And that was not the whole appeal, of course. That was just for stay pending appeal. The case was still trundling along. And so on the 24th, the clerk, or maybe the 3 judges, issued an order setting forth the briefing schedule. And I wanted to ask you guys what you thought about this schedule, because to me, it seems fast for briefing. So they ordered the on the merits brief for appellant to be filed July 22nd, and then the opposing brief August 19th, and then any reply, if there's going to be one, on September 9th. For a case that was only originally filed with them like in May. Now that to me, as an East Coast practitioner, that seems fast. Margot, I know you have more appellate experience than I do. Did that seem fast to you?
I think it's fast, but I think that it was their way to balance that they entered a stay
Uh-huh.
in this case. And also, given that this is a situation where it could very well be
Yeah,
moot if they wait
too
too
long.
long.
Yeah.
So it didn't surprise me that it has that quick of a turnaround for it. And preliminary injunctions are usually expedited as well. So it didn't strike me as that bizarre for all those
Okay. So
reasons.
right. So that makes sense.
Well,
Um,
I'll add this. Because the Ninth Circuit is so big, they
yeah.
tend to move a little faster than some of the district circuits that have fewer judges.
Right. That
I
makes
mean, they've
sense too.
got 29 full-time judges as well as 8 or 10 senior status judges. So it's and you don't have a trial here. It's not like you're waiting for transcripts and stuff like that. That
Right.
waiting on the district court's record to make its way to the circuit often builds in some delay before the briefing schedule is issued. In this case, you don't have that.
Right. So people who don't practice law understand that, because for kind of a normal case, if there's been a full trial, you have to order the transcripts. If they haven't already been ordered by one of the parties, that takes time for the court reporters to put together. So there often is a lag before the circuit even has all the materials. So, but relatively speaking, this is sort of a fast briefing. And then the sort of an astonishing thing happened. And Margot, as I said, I saw this first on your timeline. So a judge, doesn't say which one, on the docket, there's just an order that shows up on the 11th, which was Friday, right? Saying, oh, a judge of this court has decided that this case could potentially be proper for rehearing en banc, which means a full group of them, not just the 3-judge panel. Although in California, it's not the entire bench, because as Ship points out, there's like a lot of them. And the parties that are then ordered within 15 days, so that'll be July 18th, to file briefs as to why or why not the case should be reheard by more judges just on the issue of the stay. And, lawyers often ask for rehearing en banc after they lose in the circuit, but nobody asked for that here, right, Margot?
Right. That was actually because it struck me, and no one had back. And in fact, Newsom went back to the district court and said, basically, I'm going to do a going under the contest.
Oh, Margot, you're cutting in and out. I cannot understand half of what you're saying. King, can you hear her clearly or at all?
It cut in and out.
Yeah.
Yeah,
So,
she was completely electronic for me. Same, still very electronic and
Hear
distorted.
me now?
yeah, try again, Margot. Go
Okay,
ahead.
I will. Can you hear me now?
I hear you now. Yes.
Great. So I did not see anything filed where the party asked for a rehearing on bond. Newsom, in
Right.
fact, went back to the district judge and started relitigating it based on the Passe Comitatus Act. So it really makes no sense other than there's one judge who wants to write a diatribe. And the only way he can do that is if there's something the court has done that gives him a chance. So it is extremely rare for a court to call for a vote without the motion. In fact, in the Seventh Circuit, the way it was is you asked for an answer first, saying, why shouldn't we hear this en banc before you asked for a vote? And even then, it was rare, I think maybe 3 times out of 25 years that a court would do that without a party asking for it. And then what happens is the court votes, the court likely will deny it, and that will give this one judge a chance to write a dissent and say how horrible
How
Trump
wrong it
is.
is. Oh,
That,
how wrong, wrong,
yep.
wrong it is.
What
Right.
what do you think his issue is?
Trump.
The judge has TDS. That's the whole thing. Maybe the opinion could just say that, and then we could just move on then.
Right, right.
An interesting aspect in the Ninth Circuit is right now. I haven't looked at it recently, but for decades there's always been this point of view that the Ninth Circuit's incredibly liberal and I'm blah blah blah. Well, in fact, since the end of the Trump term, and I'm not exactly sure how much the Biden administration changed it, the composition of the Ninth Circuit is almost even. It
Right.
may
It's
be
not like
one
it
or
used to
two.
be.
Yeah, maybe 1 or 2, maybe 3 in the direction of Democrat appointees, but nothing like it used to be. Now, an en banc panel in the Ninth Circuit, there are 29 active judgeships, and en banc panels are 11. But because it's a random draw of the 11, you can still get a tilted panel even though the overall composition of the court is even. And that panel could tilt either direction. There's no
I
way to
wonder
really
if the
predict it.
judge who called for this would necessarily be on the 11. Do you know the rules well enough to say whether that would happen?
No, I think no. You don't. You wouldn't get the 11 until after en banc review was granted. Then they would select the 11.
Oh, okay.
But only, if I'm not mistaken, I don't think this is by local rule. I think this is by appellate rule. Margaret, you correct me if I'm wrong. I think only a full-time active judge can call for en banc review. A senior judge cannot.
Unless the senior judge was on
Was
the
on the
panel,
panel.
at least that
Right.
was,
Exactly.
yeah.
That's in the rules. I
And
agree. So, but how many to vote to take it then?
You have to have a majority vote to take it.
Of the 11?
No, the 29.
Of the 29. Okay.
Yeah. And then the panel of 11 is selected. So you can vote in favor, and you don't end up on the, which is different than every other circuit, where if you vote in favor of en banc review and there's a majority vote, you're on the panel. In
Right.
this instance, you could vote in favor, or you could vote against it, and be on the panel, or vote in favor and not be on the panel.
Right. So the judge who called for this won't even necessarily end up in the 11 if it's truly random, right?
Correct.
And
But I agree entirely with Margot. I do not think they'll take this en banc, but somebody, one of those judges who called for it, wants to write a dissent to the denial of en banc review.
so one of the 11 will do that, even if that's not necessarily the judge.
But one of the
That-
29. It could be any one of the 29.
Oh, right, because we're never going to get to the 11. Right. So, okay, yeah. So the judge who called for it will get a chance to actually do the diatribe.
Correct.
And then we'll know who it is, presumably, because otherwise there's no way to know who that judge is, right?
Correct. And, but you could have one judge write and, 9 others join, even if they
Right.
all lost,
Right.
But it's most likely the one who writes.
Right. Right. Okay.
Leslie, the part that is really funny here is the judge really wants to say something because he knows that the lower judge, Judge Breyer, is, snapping at the bit trying to issue an injunction against Trump again. It's obvious what's in the cards. So that was already going on before this vote was called.
Right. So let me.
This guy's really
Right.
desperate for
Yeah.
that.
So let me tell people what was on the docket in the lower court so they can understand the point you're making there, Margot. So this call in the appellate court for briefing on the rehearing was docketed on July 11th. On July 9th, Judge Breyer set a hearing on the preliminary injunction, and he consolidated that with the trial, which would have normally been set much later, and he set both together for August 11th through 13th. He put in a footnote, except for the stuff that's up on appeal already in the Ninth Circuit. So as Margot said, the decision on the TRO that he issued a month ago or whenever it was, 6 weeks ago now, maybe not that long, didn't include at least the posse comitatus argument. They went on the federalization of the National Guard and some other issues instead. They reserved out the posse comitatus. So he's still ruling on that.
Is that the only issue to be tried?
Well, that's a little unclear from his order. He does put in a footnote that, anything that's up on the Ninth Circuit, the parties are not expected to brief for the trial, but that at a minimum they're doing this posse comitatus thing, and then he's going to rule on that.
I think all 3 issues are open for trial, because remember the standard for issuing the preliminary injunction is just likelihood of prevailing on the merits, not prevailing on the merits. So
Right,
there'll
I
be
agree.
trial on the merits on all 3.
That's what I thought too. So I'm like, why did you put this in your footnote? Because what difference does that make to what's going to be up on trial? In the trial is not going to make any difference what the Ninth Circuit is handling, because they're still only dealing with the temporary restraining order.
Except to the extent that his lower court ruling was a question of law that the Ninth Circuit overruled him on, and then you have law of the case issue. And so it can't be revisited even in a trial. It's settled.
Right. That makes sense. But it's not like he's going to redo the TRO in the trial, right? He's going to rule on the merits. Go ahead,
He would
Ken.
have to find different facts. He would have to find
Right,
facts that change the analysis.
right,
I'd say that, but he, uh, just as a matter of appellate procedure, if the request for en banc rehearing is still open when he has his trial,
right.
uh, I don't think he can go forward on any of the issues that the Ninth Circuit has before them. They could change their mind. They could revise their ruling as to what the law is. It would be a waste for him to try any of that, except for posse comitatus.
Right. So they issued their order for this rehearing 2 days after he did this. Okay, so let me read you guys his footnote. He says the issue of President Trump's use of 10 USC 12406 to federalize the National Guard is on appeal before the Ninth Circuit. So the court lacks jurisdiction over this aspect of the case, and the parties will not be expected to address it at the August hearing. Otherwise, as already explained, the court retains jurisdiction to hear evidence and argument on the remaining aspects of the case, including whether defendants have violated the Posse Comitatus Act. So he's acting like he can't address, even on the merits, this issue about the federalization. And I don't understand how that is right, because the merits are not up on appeal.
Well, only to the extent that they they are, to the extent that an en banc panel could overrule the panel decision and change the decision on the legal questions, and then send it back to him for further, proceedings in lieu of the en banc panel's view.
Well,
Now,
and
I want to
explain
say
to
something about
people,
the
how
timing.
is that different? But see, what's up on appeal is just the TRO.
Well, no,
And
but to the extent they make conclusions of law,
yeah, okay, give us
those
an
are binding.
example of what one of those would be so people can understand.
The question of a deferential standard to the president in determining, that the preconditions of 12406 have been met. Breyer almost revisited the factual circumstances of the preconditions and just came to different conclusions than those of the president
Right. He just acted like he was the president himself and
in the
decided it.
first
Right.
instance, right?
Right. Okay. So that's a good example. So if the circuit says, well, we think you screwed that up, Judge Breyer, and here's what the standard should be, and you analyzed it all wrong, they'll send it back to him, or they could just enter in their own order saying, here's the right
Correct,
analysis.
or the en banc court could say that the panel was wrong and
Right.
that Judge Breyer does get to make his own independent factual determination as to whether or not the conditions of the statute are triggered by the facts on the ground.
Right. Okay. So what Schiff is saying, people, is that those are legal rulings that become law of the case. With the Ninth Circuit either agrees or disagrees with what Judge Breyer did, but that's still within the context of the temporary restraining order. Rulings on questions of law like that would then apply at the trial, which under normal circumstances wouldn't be next month, but would be somewhere further down the road. But I just think it's odd that he's got this footnote that's
Let me make comment just on the timing. I think there
yeah.
is an issue here with regard to the timing. One of the issues raised by the state as to, and this is a question of harm, but I'm not sure how it would tie into the outcome on the merits because it was a question of irreparable harm at the injunction stage, is the unavailability of 4,000 members of the California National Guard for service to the governor on
To
other
do
state
other
priorities.
shit. Right. Yeah.
Right. In June, when this all happened, that is not the height of the fire season in California, where the National Guard is often called upon.
Right.
August and September is the height of the fire season in California, where the National Guard can often be pressed into service. So Breyer may be looking at this saying, look, the California governor is saying that this is represents irreparable harm to him for the following reasons. In August and September and October, that very much is true in this state. So if this has been a improper federalization of the National Guard, um, if that is true, I need to decide this in return to the National Guard, the state of California, in advance of when
Before
things
that
change.
happens, right? Well, to that regard, he's got, this is not in the footnote, this is in the body of the order. He sets the date of the hearing for the preliminary injunction and the trial together, August 11 through 13. Then he says, the court will not entertain requests or stipulations for extensions of time.
Yeah, there's a sense of urgency here to
Yeah,
what in Breyer's view.
right. Now, I think that's an unlawful order, just on its face. A court cannot say there are zero circumstances, emergency, extenuating, or otherwise, on which I would ever agree to change the date of what I just ordered. That is an impossibility. So he could certainly say the court will only entertain requests for extension of time based on extraordinary circumstances, but he cannot say the court will not entertain any requests. Don't even bother to ask. Doesn't matter what the reason is. Your lead counsel has a heart attack 2 days before trial. Don't bother me with that. That's just
Maybe he wasn't watching the World Series in 1989 in October.
exactly right. Right. Yeah. California earthquakes. Huh. What if the courthouse burns to the ground, Chuck? Then what are you going to do?
Question: have there been any major changes in what's going on the ground?
Right. A question I get from people is like, why does Trump still have control of the guard? Does he still? Is
Yeah.
there like an end date? When is he going to
Oh,
turn that
absolutely.
back?
They were out. They were out in the marijuana raid this
Yeah.
past week that caused so much controversy.
Yeah.
The
Right.
National Guard was used as a perimeter force to safeguard the ICE operators who went in to execute search and arrest warrants.
Right. So this is not moot yet, but it is interesting. Margot, do you want to talk to this interplay between the two orders? So Breyer orders this preliminary hearing trial thing on the 9th, and then 2 days later, the judge on the appellate court says, "Well, we need to even revisit the stay."
I think that the judge knows nothing's happening. The appellate judge knows nothing's happening. There's no basis for him to be doing that other than he wants to write something, and that won't really interfere with Breyer going forward. What I actually find interesting is the interplay with this case and the other case where you had a federal judge say, okay, ICE, I'm going to tell you exactly what the Fourth Amendment means.
And you're going to listen for a change.
Every single circumstance, even though it's a totality of the circumstances question.
Right.
And so I think I see Breyer kind of going down his path. I think he's gonna clearly find a Posse Comitatus Act violation. I think that the things on the ground are changing, but not for the good. Someone just, fired a gun at folks trying to do ICE. So I think that that's still a problem. So I kind of see the Breyer case just, plugging ahead as it is with him already having his opinion written.
Yeah. Well, okay. So, and we were going to talk about that other case already, so we'll do that. But let me ask you to address this one point. So, if this judge on the appellate court wasn't basing this on this new order from Breyer, why did that judge wait? Because the stay was granted on June 19th. Why are we just getting this request for the rehearing almost a month later?
I don't know. The thought I have is there was some internal stuff going on. Oftentimes in the appellate level, the judges write comments back and forth to each other to try to persuade them to do certain things. So there could have been some internal wrangling going on. And then finally one just said, that's it.
Screw it. I'm pulling this trigger because I can. Right. Okay.
Yeah.
So it could not be related to what Judge Breyer is doing, or it could have been a
Right.
reaction, but you think it's more likely not a reaction to Breyer?
I think it's more likely not a reaction. Yeah.
Yeah. Okay. All right. So, Jen, do you have anything else you want to say about this before we then turn to this case that Margot's mentioning, which is it based in LA, so not in the same California courthouse as Judge Breyer. This is an ACLU case, that's been brought for the purposes of the ACLU is asserting, I'm boiling it way down, you guys, that that ICE is basically doing profiling. So there is good law in the criminal world. You know, as a defense lawyer, I would sometimes use this argument that about police officers cannot create probable cause or even reasonable suspicion to stop someone simply because the person is of a XYZ race or gender. Okay. And in some places, it's possible to prove that that happened. There was a case in Montgomery County, Maryland, where the public defender's office proved that. So with statistics and hundreds of cases being analyzed, so that was a very interesting case. But so this is a not uncommon argument from the defense bar in criminal cases that part of the probable cause analysis can't be that the person is of a certain race. The courts agree with that. So that's the underlying base of what the ACLU's arguments are, is that these ICE detentions, arrests, they're calling them, are based on race, nationality, the fact that people don't speak English, those kind of things, which might, in fact, to be fair to the ACLU, be off the table in a simple, straight up criminal kind of case. But that's kind of not what ICE is doing, right? They're not arresting people for violations of the criminal law. And there are, in fact, a whole bunch of other problems with this order. And Margot, I saw you talking about this. So you want to sort of explain, like, big picture, what's the problem with this order, which is, I would point out, 52 pages long, which should probably be a red flag that there are problems with it.
Sure. And I saw that Ship had something posted on it too. So
Yeah.
I'm gonna pull him in very quickly. But there are several problems. The first that struck me was this was filed as a habeas action. And a habeas action is where you ask the court to release someone saying that they've been improperly detained. But somehow then it morphed into a challenge of the police procedures, which normally you have to bring as what's called a Section 1983 action, and you're claiming that they're denying you your Fourth Amendment rights. So those were some of the complaint problems that I saw.
Right.
As far as the remedy problem, the major problem is at the end of the day, she says, you can't consider where they work, whether they speak English, what their nationality is, unless you can do it constitutionally. And it's like, okay, that's not an order. You
Right.
can't do that.
Right.
And you can't do it. You can never possibly enter an injunction beforehand, because by its nature, every encounter between the police depends on the totality of the circumstances. And not every encounter with the police even needs to have reasonable suspicion. You can have a consensual encounter where the police go up and say, hey, can I talk to you? Now, usually they say it in a way you think you can't say no, but if you can say no, it's not even a Terry stop, which you need to have suspicion for. So the first part of the order was nonsensical to me. It doesn't stop Trump from doing anything.
Right.
They can keep doing it and say, we're doing it constitutionally. The part that I found baffling was the court basically ordered the government to let in all these attorneys to talk to all these detainees who aren't their clients.
Right.
And I'm like, wait, how do you do that?
Right. Now, the ACLU asked for that. That was part of the procedures. They wanted these people promptly given lawyers. Okay. So,
and there's no right to be given a lawyer.
Right.
And the argument that they have a constitutional right to have a lawyer of their choice is a different thing from having a constitutional right to have a free lawyer who doesn't represent you walk in to where they're holding potentially very dangerous people from 9 to 5 or whatever hours she's.
Oh, Margot, we lost you. Can you guys hear her?
I'm sorry, I was talking with my hands again and I hit mute. But the Trump administration has already filed a notice of appeal, and I would suspect it's on that basis.
Right, because there's
But
like, as you say, multiple problems. So people
right.
know you can't
But I
issue
think it's on the basis of the attorneys
the
getting
lawyers.
access, because the other one doesn't impact them. But Ship had a really good find that the judge completely manipulated a case to support
Yes.
her decision on
Yes.
that.
And I want him to explain that. But let's make it a little clearer for people your first point, which boiled down is a judge cannot issue, it's not a proper order for a judge to issue an order that says you have to follow the law. That's not an order. That's not a temporary restraining order. But that is more or less what she did. She told them you have to follow the 14th Amendment properly and, go forth and do that. So that's the first problem. Ship, you want to explain the issue that you noticed about how the judge used some language from an Alito opinion?
Yeah, this is, I mean, it's some real nerdy,
Yes, it's in the weeds, but go
nerdy
ahead.
lawyer stuff, but it's the kind of thing that it's a nerdy lawyer thing that when you uncover it and you figure it out, you go, I can't believe she did that.
Right.
Um, and a lot of times, this is sometimes these are clerks that pull this kind of crap, and the
Yeah.
judge is too trusting and doesn't go back and look closely at what they did, and they pull something out of context, and then because if you just clip the words just right, it sounds like what you need it to sound like, but you have to ignore everything else around it and the context, as I
And in a
suggested.
long order like this, it's more likely that the judge then doesn't notice, wait a minute, and they haven't probably read that case, right?
Right,
The
right.
judge herself, yeah.
So this is it's a jurisdictional issue, as we have discussed and I've written about many times. In I think it was 2005 amendments to the Immigration Nationality Act, Congress went out of its way to try to minimize, to the greatest extent possible, the jurisdiction of district courts on immigration issues. It expressly set up that judicial review of the outcome of immigration court proceedings goes directly from the Board of Immigration Appeals to the Circuit Courts of Appeal. Not There's no role for the district court to play. And in fact, the statute makes specific reference to, notwithstanding habeas corpus statutes, which
Right.
means don't even use habeas corpus statutes to try to get immigration matters into district courts. Um, so there's the provision, there's two provisions in section 1252. One says the exclusive jurisdiction for judicial review of final orders of removal is the circuit courts of appeal, and the other one says no court shall have jurisdiction except as provided in that earlier provision. So this is always something that the plaintiffs and these district judges have to try to sidestep their way around. Is how is it that a district court has jurisdiction or lawful authority to enter any remedy in a case that shouldn't even be in district court? And they're ignoring these jurisdiction, they're ignoring the jurisdiction stripping provision to simply throw sand in the gears and get the injunctive relief in place for some period of time until the government has to continue to expend resources on a case that shouldn't even be filed. So in this particular case, there's multiple aspects that are being challenged here, as Margot pointed out. The judge in the case divided the class of claimants into two large groups. One class of claimants involves the conditions at the detention facility and the access to counsel. And then the second class of claimants involves those with claims relating to detention and apprehension. So what happens to you with ICE out in the field is one group, and how your detention is managed and your access to counsel is a different group. Well, there's the statute in question. I don't have it in front of me, so if somebody can pull it up and you can lead through the language, it would help me. But the statute in question basically says any claim arising from the enforcement of an order of removal, it has to be taken to the Circuit Court of Appeals and not in district court. So the government raises this jurisdiction stripping statute because 1252 section B9, and the judge sidesteps it, and she says, the controlling authority on this provision is Jennings versus Rodriguez, decided by the Supreme Court in 2012 or 2018, and the Supreme Court said in that case that, and then this quote is she quotes the last sentence of the last paragraph, or not the last paragraph, of section 2 of this opinion. This is nerdy stuff. And that says basically that cramming all claims that arise from the order of removal into the Circuit Court of Appeal judicial review is absurd. Now, that language is in Justice Alito's opinion. It says, basically says you don't cram everything having to do with an order of removal into the Circuit Court of Appeal provision. Doing so would be absurd. Now, in his opinion, though, he had given 3 examples of the kinds of things that could arise from an order of removal that certainly just, it's obvious, wouldn't belong in a circuit court review of the order of removal. And the 3 examples he gives sort of 3 examples to demonstrate the absurdity. One is if the alien wanted to sue law enforcement officers in a Bivens action for having violated the alien's rights. Well, that wouldn't be, that would arise from the order of removal. It's part of the enforcement mechanism. But you wouldn't say the Bivens action to go through the appellate court review. Bivens action is independent cause of action that begins in the district court. Nothing to do with the order of removal. Second example he gave was, I'm taking these out of order, but the third one is one I remember the most. It's like you're being transported in an ICE van, and the driver of the ICE van runs the car off the road, and you're injured.
Right.
Well, that's certainly a claim arising from the execution of your order of removal, but you wouldn't say judicial review of that claim has to go through, the INA.
Oh, you cut out.
Gives us 3 examples. It says he's cramming those judicial review. I can't remember. I don't have the language to my phone, but basically, when he says cramming judicial review would be absurd, he's talking about his 3 examples that he just gave. But the way the judge carved up the quote, they eliminated the word those, meaning his specific reference to his 3 examples, and just made it a generic cramming.
Right, as if it covered everything.
Any kind of judicial review. That, in other words, the door is open to district judges to pick and choose which kinds of claims would be subject to judicial review in the district court and which would not. Not the nature of the claim, but the judge's election. It sort of created this. Now, the broader problem, though, is that later, 2 paragraphs or 3 paragraphs later in the opinion, Justice Alito says, but we don't even have to consider this because the parties have not briefed the scope of the jurisdiction stripping statute. In other words, that really wasn't even part of that case. It had just come up in the argument, And he says, the parties haven't briefed it. We don't have to reach it because, of course, this is not like, and one of the examples he gives is, it's not like they're contesting their arrest and detention.
Right.
His point being that would certainly be subject to the jurisdiction stripping statute. That is exactly the kind of thing the Congress took away from district courts. So
Right.
not only did she carve up that quote in a fashion that made it not representative of what Justice Alito actually wrote, she came out the exactly opposite of what Justice Alito was
meant
saying
right.
when you read 2 paragraphs down. Now the ultimate legal nerd thing is, as it turns out, this is section 2 of his majority opinion, but only 2 other judges joined section 2, and that's explicitly in the opinion that section 2 was only joined by Justice Alito, the Chief Justice, and Justice Kennedy at the time, and nobody else.
Right.
So it doesn't speak for the court. It only speaks for 3 justices that joined it. It's not considered part of the opinion of the court because it didn't get 5 votes.
So
she cites it as the controlling authority.
Yeah, she cites it as if this is what the Supreme Court said. So it's not only not what the court said, but it's also not what Justice Alito said or meant. So,
Right.
Yeah, so that's a problem. And if you did that as a lawyer...
So let me ask you this. And I want Margot's input on this. I want King's input on this. I want your input on this. If you all looked at it, if you all looked at the language, am I right? Did she completely transform what the actual opinion says?
Well, I didn't pull Alito's opinion to look at it. King, did you or Margot do that? We were relying on you, Ship. Maybe King looked at it.
No, I did not either. But what King says, I mean, what Ship says sounds reasonable. It's you can't toss off a sentence like that as the holding of a court and the controlling part of the opinion under those circumstances. Just it would get a first-year law student in trouble with the professor if you did it.
Well, I think you'd be in trouble as a lawyer, don't you guys? That if you cited that to a judge in that way, but when the judge pulls up the opinion, well, no, that's not what the justice said and meant, and also only 2 other justices agreed with him. Like, I would never do anything like that.
Right. I absolutely agree. And Ship, I didn't read the case, but I read your analysis that you had written up, and you're spot on with the analysis unless you parsed the quote the way the judge did.
Right.
So I absolutely agree. I don't necessarily think that this is arising out of in a way that would bar jurisdiction, but I also don't understand how there is jurisdiction given it was brought as a habeas. And habeas by its nature is you're detained unlawfully, and yet what she's saying is you can't detain other people. And to the extent...
Okay, so...
Go ahead.
Let me see if I can clear that up. You're absolutely right. And I went back and looked at the docket, and the initial filing was a habeas. But if you look in the procedural history of her opinion, she goes through the fact that a complaint and a First Amendment complaint were later filed. My question was, why weren't they filed as separate cases? Why are they filed under the same case number that began with a habeas complaint? Why has she allowed that to happen? And make
it as confusing as possible.
Right, and then you have the question. She has these organizational plaintiffs in there, and and you see this now. You saw this in Planned Parenthood too, which I'm anxious.
Oh, Ship, we lost you. You're talking about Planned Parenthood?
I think that I can...
I think he's heading down the standing road.
Yeah.
Right.
Yeah, go ahead.
Harm road, because the harm in the Planned Parenthood, the judge claimed, was not having the ability to get care, but those weren't the plaintiffs. And in this case, the harm the plaintiffs, these institutional characters, are claiming is, well, they're harmed in their mission, which is providing these services. Well, if that's your basis for standing, then you got to let everybody have access to these attorneys. So I think that was pretty striking. Ship, you want to try again?
He's fallen off as a speaker and is only now a listener. So I'm going to invite him to speak again. Ship, I think you can hear me. I'm sending that to you. It'll.
While you're doing that, can
Yeah.
I ask a question?
Yeah.
What was the factual basis for this judge going this far? What are the facts that the judge found were alleged, and evidence presented to support that justified this kind of judicial reaction?
So in this case, there were a couple plaintiffs who are apparently American citizens, and they were briefly detained while the ICE folks were doing a broader raid of the area. And when the agents were asked for why they chose different individuals, the judge said that there was no way, they didn't provide anything specific in the context. So she portrayed it as basically a group of masked people jumping out of a car and surrounding a bunch of people and arresting them
Right.
for
She
no
posits.
reason.
Yeah, she posits that there's two that yes, ICE can do enforcement in California, but that there are two issues. She says the first is, are these folks who've sued likely to succeed in proving that the government is conducting roving patrols without reasonable suspicion and denying access to lawyers? The court decides based on the evidence that they are. And second, what should be done about it? She says the plaintiffs have asked the court fairly modest requests that the court order the federal government to stop doing that, basically. So, it gets into the questions of, well, how much suspicion or cause is needed in order for the ICE officials to act. And so, we're back to sort of my original setup for this, which is, right, they can't just arrest people, immigration or not, just purely on their race, right? That would be illegal if that was the only thing that was being taken into account, for sure. But the question is a lot murkier than that, because you're not talking about officers who are personally observing violations of law, right? They don't know the person's status. Now, there might be cases where they could know an individual person's status. Let's say they've been casing out a business that employs a lot of day laborers. In theory, the government could have personal identifiable knowledge about individual workers to know what their immigration status is. But so those are sort of the two extremes. But I think the reality of the facts on the ground is that it's somewhere in between, right? So the government is conducting raids at places where they believe people who are in the country illegally are gathered for employment or for other purposes, and they're scooping them up. And one of the things that they're doing is basing it on their whether they can speak English or not, right? And the kind of work that they're doing and other factors beyond their race. And to be honest, as a defense lawyer, as I say, factors that probably wouldn't cut the mustard in criminal cases, where the court would probably say, this is not based on suspicion of illegal conduct, but just this person falls into a category that you don't like. A criminal when you see one kind of analysis. And I think, as we've talked about with the judge in Maryland, this judge in California, this opinion reads to me more like a criminal case rather than an immigration case, because the factors are not the same. Comments from anyone?
Yeah, I'm not. I have never looked closely enough at the differences between the justification that a border patrol agent needs as opposed to a FBI agent to stop and detain somebody for investigatory purposes.
Right.
They are different. There's case law that distinguishes the two circumstances. Um, I don't know this for a fact. This is a guess. I'm happy, if somebody has information, I'm happy to take a look at it. My guess would be most of the people that are actually getting detained are either admitting that they're illegal or they have previously been removed, so they have an A file that says they're subject to immediate removal. And that where they don't have either, where the agents don't have either an admission that is subjects the person to immediate removal or a previous order of removal, those are people aren't getting detained.
Right. So what
You
they
know,
were doing here, she's got a few facts here, is they were conducting raids outside of a Home Depot where people are sitting around for day labor work, right? They were doing this at car washes, agricultural workers, street vendors, recycling center workers, a tow yard, packing house workers, right? And the government didn't say they weren't doing that. They were saying, what looks to the outside world as we just show up one day and arrest all of these workers, you're seeing the end result of the work that we did to determine that these workers are likely not legal.
exactly right. And but even when they do that, she's saying that enforcement tactic is impermissible.
Right.
I'm
Now,
saying
they
that
weren't just Terry stopping them, though, Ship. They're
no,
arresting
no,
them.
no.
They're taking them
I
away.
no, I
Yeah.
understand. But who are they taking away?
Right.
My question is my suspicion is the ones they choose to take away are either admitting that they're illegal or they have an A file. If they don't have one of those two, just put that person aside.
Well, because if you're a U.S. citizen working at this tow yard, and these guys roll up and they say, "Hey, we're arresting you," and you say, "Oh, no, no, can do. I was born in the great state of Ohio. Go Buckeyes." That's going to be a problem if they then decide to arrest you.
And it's not a fight that they want to have right then.
Right.
There's plenty
Exactly.
of it's like it's the old song. It's like there's plenty of actual illegal aliens to
Right.
choose from. You don't have to pick the hard cases where the person speaks English and says I'm a citizen. It's like, well, okay, but if you question 25 people and 10 of them have A files and 5 more say that they admit that they're illegal, well, take those 15 and move on. Leave
Right.
heck with the other 10 for now.
The problem seems to be that they're kind of taking them all and then
I
sorting
don't.
it out later at the ICE facility. But I'm not sure that
I'm not
that's
sure they're doing that. I'm not sure they're doing that.
The, it could boil down to the process of just grabbing a bunch of people. Nobody leave this room until
exactly. And then
we talk to
sort
you,
it out later.
I
Yeah.
think
and
that's
we
right.
sorted it out right here.
That tactic.
But
I think you're right. I
that
think
that
that
ta-
tactic is what she is disapproving of.
Right.
yeah, that's what it feels like to me.
Right. So this raises the issue, which I think people don't understand, of okay, well, how much information is required before the government can detain you and or haul you off? Now they are characterizing this, and the judge does several places in this order as arrests, not simply detentions or stops. So the statute says ICE officers only have to have reasonable suspicion of an immigration violation in order to question people. That's similar to what the law allows on the criminal side too, right? This is what lawyers on the criminal side call reasonable articulable suspicion. Specific facts from which the cop can say, I think this person is involved in a crime. And that doesn't have to be probable cause. It's less than that. But that gives police the ability to stop and ask you questions, stop you, and you can't walk away at that point, right?
Right, and it does not require individualized assessment of the person being stopped. It can be based upon patterns of criminal activity in that particular location that the police have witnessed historically.
Right. To go the step further, to arrest, there has to be probable cause. Now, a
Yes.
lot of people think that means preponderance of the evidence because they think probable means more likely than not. But the Supreme Court says no. They say probable causes can be something less than 50% preponderance, but not a whole lot less. It's somewhere, if you had to put a number on it, it's kind of somewhere in the 40s, right? Like reasonable suspicion is even less than that, like maybe 25%, right? Probable cause is not more than likely that the person is illegal or has committed a crime. It's just a common sense determination of it's pretty likely that that's the case, but doesn't have to be 51%. That's the state of the current law for an arrest.
Right. And an immigration detention is something less than an arrest.
Right. Now
Because
this
you're not depriving the person of their liberty on the suspicion of criminal activity. You're depriving them of liberty that you don't think they're entitled to.
Right. And we do this in the criminal court on depriving you of your liberty for a criminal offense. And the government can hold you for, what is it, 72 hours before they have to take you in front of a judge on that basis.
Right.
So I'm not
Do you
sure.
all
Go ahead, Margo.
do you all agree with me that her order doesn't really tie Trump's hands at all under how ICE can execute their searches?
I thought your comment online, I think I attributed to you, was you're prohibited from breaking the law.
Yeah.
That was
So
perfect.
stop doing that. And they're going to say, well, we're not doing that. So, okay, there you go. Right.
Although, if you noted, one of the things she did in what she framed as a show cause hearing for why not to give a preliminary injunction, she's floating the idea that now ICE has to do this special training and tell her what these standards are, which is ridiculous because you can't possibly give every single factor that you're going to consider when you are deciding whether or not to briefly detain someone, a stop, or arrest them. I am also curious, though, what do you guys think about her order that the ACLU or whatever these groups of attorneys are get access to all the detainees?
Yeah, that to me, I didn't read that closely. I didn't, so I don't know what all but she imposed a bunch of specific requirements for, where, because there were allegations they're not getting food, they're not getting water, some of the rooms are not big enough to sit down in, they have to stand, all kinds of anecdotal information that who knows how accurate it actually is, with regard to the facility that was being used. But she, in effect, under a TRO, issued a whole list of policies that ICE has to respect and comply with.
You know what it reminded me of is in the past, pre-January 6th, when there would be large protests in DC, you would effectively get this same kind of thing from the Superior Court and law enforcement authorities in DC, where they would just say a bunch of lawyers are going to be allowed, right, to come in and represent these people because the volume is such that
Mr.
the court is
President,
not going to be able to handle this any other way.
what an
and so,
honor.
But that's a criminal issue,
Yes,
and you have the right to counsel.
Right, I know, but I'm saying this judge, this order reads to me like this is the mindset of this judge.
Right.
Again, we're faced with they're trying to use the criminal process as a model for how to handle this, and it really kind of doesn't work.
And not only doesn't it work because the rules are different, the standards are different. She's in an environment she doesn't belong.
Right. So let's switch then over to the Planned Parenthood, because I agree with you, Margo. It's got a similar feel to it, doesn't it? And plus, we don't want to hold you longer than you can stay. All right. So in this Planned Parenthood case, which is where did I put it? I can't find it.
Planned Parenthood vs. Kennedy, District of Massachusetts, Judge Talwani.
Right, I'm looking for my order. Oh, I know, I didn't write it down. I just downloaded the pleadings. Okay, so the government moved to dissolve the TRO for the reasons that we identified last week, that TRO was all kind of messed up procedurally and was basically a TRO issued without notice to the defendant, but didn't satisfy the requirements of issuing such a TRO, which can be done, but there are rules for doing that. And the judge basically just blew by all those. So the government filed a motion to dissolve the TRO, which Ship, you had predicted that they would probably do. And they raised a bunch of issues about, pretty much they raised all the technical stuff, right? Why the order was wrong. And they did that on the 11th. And the same day, without even waiting to hear from Planned Parenthood people, the judge amended her order and issued a new TRO with, more explanation, sort of why she was doing what she did. And that is kind of where it stands at the moment. Did you guys read the any of those pleadings in the amended TRO? Let me ask before we.
I did, and a couple thoughts. One, the TRO, beyond all the problems that you all pointed out, it still stands because she still has not heard from the government. And she's lacking like, oh, well, that's not a problem because in 2 weeks I'm going to hear from them.
Right.
No, you can't issue a TRO unless you hear from the government, unless there is some extraordinary problem. And she never says what this extraordinary problem is that prevents her from hearing from the government.
Substantially on the request for the restraining order. Right.
Right. Instead, she focuses on what the harm would be to the clients. But 2 points here. That still is not talking about the harm before she has a chance for the hearing. What harm would have happened if you waited 2 hours or 1 day or 2 days? She never explains that. Secondly, the clients, the patients of Planned Parenthood are not the plaintiffs. The harm to them is irrelevant to, is there irreparable harm to Planned Parenthood? And here, I'm going to tag off of what Ship did in the other case. She cites a case that takes completely out of context what happened. She cites a Planned Parenthood case that says denial of medical benefits or medical treatment is irreparable harm. But in that case, the clients, the patients, were the plaintiffs. That's why that case has no bearing on it.
Well,
The
there's
second part,
there's one individual in this case, Margot, not just
I
Planned
didn't see
Parenthood.
that.
Yeah, her name is.
When was that added?
She was in the. She doesn't get talked about much. Is the problem, especially including by the judge. Because I agree with you, the judge is kind of using the Planned Parenthood entities as a proxy, right?
What's the name? What's the name? I looked
right.
at that closely.
All right.
I didn't.
I'll
Yeah,
have to
I did
pull it
not
up.
see.
Hold on a minute here. You guys keep talking, Margot.
Because it was the
pulling
Planned
that up,
Parenthood Federation of America, which is the umbrella entity that doesn't provide any services itself, and on behalf of itself and 47 members, affiliates, and then Utah and Massachusetts. And I think those two were chosen because one, it gets venue in Massachusetts, and the Utah one was chosen because abortion is illegal in Utah, so they don't provide abortion services. So why are they being cut out?
Why are they cast out? They may, they're right, because the law might not apply to them, in fact. Okay, so this individual is not showing up as a party, but she's all over the affidavits, and I think that's why the judge is going that way, right? She specifically is a patient of the Planned Parenthood League in Massachusetts and claims she won't be able to get care, right, from them for her non-abortion needs, right?
Yeah, this is the point that Margot raises, is that you're granting a TRO on the basis of harm to a non-party.
Right.
And that harm can be considered when you look at the public interest, but not the requirement that there's irreparable harm to the plaintiff, which is Planned Parenthood. But I want to point out another flaw here, which is the only claim that the judge finds there being merit on, is the right of association claim.
Right.
And that claim only would apply to a very few select Planned Parenthoods who don't provide the abortion services, which would mean the injunction should have been limited, even if you assume that she was right on everything else. It should have only been to a few of them. But she grants it carte blanche. And again, she does it without saying why I have to enter it now. And if you actually read the TRO that Planned Parenthood filed, they drop in a footnote, and what they say is, we can't now bill Medicaid.
Right.
We're not getting paid, but they can't bill Medicaid. That is not an irreparable harm in general, much less one that would require the court to grant the injunction before the government has a chance to come and talk to the judge and say, this is why you shouldn't grant it.
So she just treated it as if it is a kind of a more standard case. This is preventing people from getting medical care, and that is an emergency. And on different facts, it would be. But that's not really what's going on, at least as these people have put the issues in front of this judge.
Exactly.
If you'll recall last week in my shortened participation, I said, oh, she's going to claim they got notice. You wait, she's going to claim they got notice.
Yeah.
The email was notice under
Yeah.
Rule 65. And what did she do? She pointed out that they got emails.
Right. And I'm outraged by that as a practitioner because, you know, Steve and I were talking about this earlier this week. When I was a young lawyer, I was at a firm that did a hefty number of cases where like one employee left one company and went to work for another one, and they had trade secrets allegedly, or customer lists, or, you know, blah, blah, blah. And so the companies would be suing, trying to enforce their confidentiality agreements or their non-competes, or the employee would be trying to get out from under a non-compete, saying it was overly broad, blah, blah, blah. Those cases almost always involved emergency relief, right? You were either trying to get it or you were defending on it. And you know what? We would give notice to the other side before we filed the lawsuit, or we would get notice because you would know who the other company's lawyers were. And you would both go together and talk to the clerk's office about getting in front of a judge, getting on file, and getting a TRO lined up quickly. So I don't understand how it is that Planned Parenthood wasn't actually able to get actual notice to the government and is simply relying on, oh, we shot off emails and then we went off, hauled off and filed. King, I wondered what you thought about that as a civil practitioner.
As a largely civil,
Yeah.
in my experience, that's the first question the judge asks.
Right.
Did you tell me what the other side says? Have you talked to them? Have you given them notice? If not, why not?
Right.
Can we do it right here from my chambers?
Right.
Let's call.
Right.
Let's call.
Right.
I can get a hold of the government. Can you? I got some numbers. Let's call.
Right.
So it's very shady on both the plaintiff's part and the judge's.
Right. Why didn't the judge instruct them to get those government lawyers on the phone? She waited for hours before hauling off and issuing this TRO. What, they don't have the phone number for the civil division of the U.S. Attorney's Office in Boston? I don't believe that. Now, maybe you can't reach whoever's ultimately going to be assigned to this case at whatever division in DOJ is going to handle it, but you can get a government lawyer on the phone.
If they don't work for the IRS, that's absolutely true.
Well, it did used to be easier, I will say, in the old days than it is now. But I just think this is part and parcel of, we just use the ECF for everything now, right? And it's like, well, we know that they're going to get that through the the mysteries of the ECF filing system, and so they got it. Well, how do you know that they got it? You didn't make any efforts to independently try to get to them. So, especially because Planned Parenthood was saying to the media before President Trump even signed that bill that they were going to be suing based on that provision. It's not like they didn't know this was coming.
You know, I posted something. I don't know. I can't remember if I wrote an article about it or I just posted it on X. But you know, there's a certification that was attached to the TRO motion
Right.
under Local Rule 7.1 in the District of Massachusetts, and that's where they wrote that they had, you know, sent emails to the following individuals, and as of the time of the filing, they had not received a response. Well, that certification under Rule 7.1 says that before any motion can be filed, the parties must confer to see whether or not the issues presented by the motion can be, you know, eliminated or narrowed.
And
Well,
that's a common rule for those of you who don't practice law. That's a common rule everywhere now in state
right,
and federal courts.
right.
That the
Before you
courts are
file,
like, did you try to work this out before you come and ask us to rule on stuff?
right. How does sending an email satisfy that rule?
It doesn't. It didn't last time I looked.
Right, right. You know, and the rule, you know, requires a certification that you have made an effort to contact or discuss with the opposing counsel the subject of the motion.
I mean, even it seems futile a lot of times because you know the other side isn't
Well,
going to agree
sure,
to
sure,
dismiss their case. But nevertheless, the courts are right to expect the lawyers to try to at least narrow the issues.
right. And so so this kind of goes to King's point. You've got the names of individuals. To simply say I sent them an email and they didn't respond is not the equivalent of saying I called them on the phone and they refused to discuss it. You know, you can't
Well,
even confirm that they got the email or anybody read the
Right.
email.
yeah, but I want to weigh in here on this because the court rules that require consultation make sense in many cases. Like, there's all sorts of motions that are not time sensitive, and there the court's absolutely right that before you bother it, you ought to see if you can work it out between yourselves. But in theory here, I'm not saying in actuality of these cases, but in theory, if you've got an emergency facing you that is so urgent that you need a TRO, you don't basically have time to be calling the other side or do much more than flipping them an email.
Well, and that's why the rule that allows for a no notice TRO exists. But here, as we said last week, Planned Parenthood was not trying to invoke that rule. They were trying to use the normal rule. So what's their excuse for
Yeah,
not?
and I agree 100% with your point, Steve. I agree that that rule is written for the typical filing of a motion, which comes after the case is already sort of on its way. And you know, and you're arguing about discovery or deposition scope or whatever. That's what that rule is targeted at. I agree. But Planned Parenthood chose to put that certification and include their Rule 65 requirement or obligation to provide notice
Right.
in the context of that 7.1 requirement. They didn't have to do that. I agree with you that to me that's not a TRO is not what is intended to be the subject of the Rule 7.1. But I think they owed one, they were required under Rule 65 to make either to expressly say we're asking for this on an ex parte basis without notice, or to make a better effort at notice and then explain what they tried to do.
Right. I don't think they were expecting her to haul off and do that. They asked for expedited briefing.
I agree. They did. It is not captioned. And this is another
Right.
curiosity.
Right.
It's not captioned an ex parte motion for
Right.
TRO.
Or even emergency, although maybe.
Right.
But yeah.
But you know, curiously, the TRO in California was called an ex parte TRO, even though
Oh my
it
God.
was briefed, opposed, a reply, and a hearing.
Right.
And the judge still called it her ex parte TRO. It's like,
Right.
what school did you go to?
Right. I know. Right. Do you read any of the stuff that you put out? Yeah. So, right. So this Planned Parenthood, okay, so the government moved to dissolve the TRO. And without, again, this judge likes to do things without hearing from the other side. So without hearing from Planned Parenthood about that, she amended her TRO and She basically tried to fix the procedural problems, right? But the substance of it is not really any different. But I'm with you, Margot. It's like you can't fix your TRO problems by saying, "Oh, but I'm going to hold a preliminary injunction hearing next week."
Well,
Now, I'll say on that point, she set the PI hearing 14 days after the TRO was entered, which is the max allowed by statute, although the rule says that a TRO granted without notice must be set at the earliest possible time.
Right.
Or words to that effect. Which it would not necessarily be the 14-day limit for having the preliminary injunction motion. However, before she did that, the government came in and said, we're okay with that date. The government didn't ask to have the hearing accelerated. They chose to file a motion to dissolve instead, rather than say, we want to accelerate the hearing date up 10 days and not wait 14.
In the meantime, Planned Parenthood asked for the date to be extended by 3 days. They
3 days.
did oppose that and proposed an earlier day. So it ended up
And
getting moved
she
up
gave them,
by 3
and she
days.
gave them the earlier date. She
Yeah.
gave the government the earlier date.
Yeah. So, I mean, they had to pick their poison, the government, right? How are they attacking
I actually
this?
I think they recognize that look, the way Medicaid works, there's really she's not preventing anything with her TRO the way Medicaid pays out.
Right.
And that I think their view was, I think we talked about this. One, they moved to dissolve the TRO in the first instance, and two, they're just briefing the PI because they're highly confident on the merits that either she's going to grant a ridiculous PI regardless of what they argue, which in that instance they're actually targeting the First Circuit,
right?
Or they're going to make her understand that, nice try, but this is a bridge too far, even for Planned Parenthood.
Right. So, all right. So that's kind of where that stands. Shall we switch over to Kilmar Abrego Garcia?
We still have. Why don't Margot? You got anything you want to wrap up? Anything? I know this is the one that you came most prepared to talk about.
Yeah.
Yeah, I was just curious if anything's going to happen until the PI. Is Trump going to try to challenge what she did, or just sit on it and it made the point that these judges are acting crazy and wait until she does something with the PI?
I think they're going to. I think they're committed. I think they believe she's a lost cause because she's done crazy things in the past in other cases. So I think they look at it. They're just wasting time in her courtroom, and they're headed for the First Circuit. Although with the composition of the First Circuit, who knows if they're
right. As we discussed, there are a bunch of loons on that court. So
right.
Yeah. Yeah. Well, Steve points out they're smart loons, some of them. So. Well, okay. So that takes us to Kilmar then. So here's what's going on with that. We wondered last week what his lawyers in Tennessee would do, because there the government is trying to get the district judge to overrule the magistrate's ruling that Garcia should be released. Now that doesn't mean let go. That means basically transferred from the Marshal Service to ICE. So the magistrate ruled based on the Bail Reform Act that the government, for various reasons, didn't make a case that Garcia should be detained criminally. And they have a right to appeal that to the district judge, which they duly did. And the judge had given Garcia's lawyer some dates to respond. And they filed their opposition. His lawyers, Garcia's lawyer, they filed a normal opposition. I was fascinated to see what they would do. So their position, Garcia's lawyers, in his criminal case in Tennessee, their position still is that he should be released, even though they know if he does get released, he's going over to ICE and then he's going to be deported. And their opposition reads like that case in Maryland kind of doesn't exist. They only refer to it in one footnote. And in that footnote, they talk about what the government has been telling Judge Zenas that they're going to do, which is deport him, right? So, and I was wondering about that because it struck me as potentially unethical for his lawyers to have come to the court and said he should be released. And then later, after the judge in Maryland says, yeah, but they're going to send him to ICE if you do that, they go back and say, oh, well, actually, we don't want him released. And we want to say the opposite of everything that we've been saying for the last month. So they didn't do that. I'm impressed with these lawyers, which I think is the public defender in Tennessee. They're sticking with they're dancing with who they brought, right? Saying, nope, the government is wrong that he should be detained under the Bail Reform Act. And I guess they just figure that his lawyers in Maryland are going to have to sort out the rest of the issues. So meanwhile, the government can file a reply to that if they want by the 14th. And so there's no ruling from the Tennessee judge yet. And I think he set a hearing for the 16th. So we should get some more clarity from Tennessee this week. Meanwhile,
Quick, I got a question. How hard is the government objecting to release?
oh, they're pulling out all the stops. They're making all the arguments. They really want that magistrate judge's order overturned. So if you just looked at the pleadings in the Tennessee case, it looks like a normal case. The government wants him locked up. His defense lawyers want him out.
My guess for that tactic is if he remains detained on the criminal charges, then we can sort out everything with Judge Zenas without the drama.
Yeah.
Of is he going to Sudan? Is he going to Libya? Is he going?
Right. Who's doing what? Who struck John? Right. Exactly.
Yeah, he's not going anywhere, Judge Zenas. So let's turn the heat down and resolve this case in Maryland and get rid of it. And then what happens to him in the criminal case or in the follow-on immigration proceedings will happen in due time.
Right. Okay. So when we left the scene last week in Maryland in front of Judge Zenas, she had ordered a hearing to take place on the 10th, which duly happened on the 10th and the 11th, where we talked about this last time. She ordered the government to produce basically somebody who actually understands the immigration statutes to explain them to her, because the DOJ lawyers couldn't do that to her satisfaction. So interestingly, the day before the hearing, the government filed a stipulation. Did you see this stipulation, Chip?
Yep.
Okay. So in this, you want to describe it or do you want me to?
Well, I don't have it in front of me.
Okay,
I kind
I'll
of
do
have
it.
a recollection of what it
Yeah.
said. But
So the stipulation basically says what you said the government's position should be. So I thought this was very interesting. They basically filed the stipulation to the judge. Now, a lot of times a stipulation is joint between the parties, right? The parties are agreeing. These are facts that we both agree on. The government says it tried to get Garcia's lawyers to agree to this stipulation, but Garcia's lawyers would not go along. So they filed it anyway as kind of a one-party stipulation. A one-party stipulation, you're basically telling the judge, these are facts we concede. So they said in the stipulation, the government did, that they were going to deport him if he comes into the custody of ICE, remove him, but not to El Salvador unless they first went back and reopened his immigration proceedings and got the part taken out that he couldn't go to El Salvador, which he had asked for and been granted by an immigration judge. So basically, part one, we're going to deport him, but not to El Salvador unless we get that limitation changed, or we're going to deport him someplace else pursuant to the procedures that the government had described to the Supreme Court in their request for a stay on that case that we talked about up in Massachusetts, where the new judge up there was giving the government such grief about sending those guys to South Sudan. So it looked to me like they were trying to head off some of the problems at the hearing by telling Judge Zenas, we are going to remove him if we get custody of him from the marshals, but we're not going to make this mistake that we made before and send him to El Salvador unless it gets worked out that that's okay to send him to El Salvador through the immigration process. Okay, so they filed that on the 9th. They had the hearing on the 10th and the 11th. And then on the 11th, Judge Zenas issued an order on the docket that says, which she apparently announced from the bench, She's taking all of it under consideration, and as of yet, she hasn't ruled on it. So, Margot, Ship, were you guys following the hearing at all, either live or through reporting?
I did not listen to either session live, regretfully. I wish I had. I'd read, more than one, sort of running blog,
Yeah.
so to speak, of a couple of different people who were in the courtroom or watching in the media room.
Yeah.
So,
but let me Ship. Let me interrupt you, Margot. Did you listen to it or?
I didn't listen. I was doing the same.
Yeah,
I was following what other
it.
people had.
Okay. I didn't have time to do that, you guys. So lay it on us. What actually happened at the hearing?
Margot, go ahead.
Basically, the judge hates the DOJ, thinks they won't tell her anything, and thinks that their stipulation isn't going to protect Garcia from what his attorneys are afraid of, which really is the nub here. The attorneys want Garcia to have a better protection that he's actually entitled to. He's not entitled to 2 weeks notice that they're going to send him to South Sudan. His attorneys are trying to force that. The other part that struck me was that the judge recognizes that she really doesn't have authority to order where Garcia is detained.
Right.
But she wants to figure out a way that she can do it. And that's why she's taking it under advisement, that she knows that the government's right on the point that whether and where an alien is detained by ICE is totally up to ICE. It's not up to her. And her fear is that he's going to be detained somewhere where she can't meddle and prevent a removal.
Yeah, the problem, I'll jump in. The problem with the stipulation that the government offered, the devil's in the details there.
Yeah.
Because in the procedure that the government outlined for the Supreme Court in the motion for stay, with regard to the third country removal, that procedure basically says that all of the necessary process has already occurred. And therefore, the third country removal will happen almost automatically without any further process in a court or in an immigration court or any other court. So that option, the third country removal option, is exactly what they fear, is that 30 seconds after he goes into ICE custody, he's going to be in a van headed to the airport,
right,
with destination
got
being
a
South
seat
Sudan
with his name on it. Right.
Right. And what she keeps saying, and this is where I think she is simply not understanding or accepting that Supreme Court case that the government is relying on, I've briefed a couple of times, is that she keeps saying, well, have you gotten assurance that he's not going to be persecuted or tortured?
Right.
That's not what the case requires. The case, it's not an individualized assessment for a particular defendant that particular defendant won't be persecuted or tortured. When the Secretary of State enters into an agreement with the foreign country and the case that this is based on actually involved an American citizen being turned over to the Iraqi Provisional Authority, that essentially the fact of the agreement, the court presupposes that the government has already received those assurances, and it's not for the court to second guess the agreement entered into by the government. And so she wants them to explain that they've already got the assurance for Kilmar Abrego Garcia, if sent to a third country, that he won't be persecuted. The government said, we don't have to do that. We just have to have our agreement with the government is a representation that people we send will not be persecuted. Otherwise, we wouldn't have entered into the agreement.
Right. It's basically they're getting assurances, was the word they used with the Supreme Court, from the other government that government doesn't torture their prisoners, basically.
Right.
As a systemic kind of thing.
And you have to have that assurance as a precondition to the agreement. The fact
Right.
that the agreement is already in place means that assurance has already been given, and
To
the
State Department's
unanimous
satisfaction.
right,
So,
and the unanimous Supreme Court has said it's not the role of the judiciary to second guess the terms of that agreement.
right. I would say, having appeared in front of Judge Zenas, Margot, I don't know if you heard me talking about this last week, but she's an extremely smart person. And I would say she was a federal public defender for a long time, so I'm not surprised that she's got little use for DOJ when they're doing what she thinks is gamesmanship. But she also, when she makes rulings on things, especially when she reserves on them, I don't think you can completely tell from the nature of her questioning of the parties that that's how she's going to come out. Because everything that I've had in front of her, she has researched it to the nth degree. If there's any legal, sort of complexity to it at all. And she's going to make her own independent assessment of it. So I'm interested to see which way she comes out, because I could totally see her blasting the government throughout the whole hearing. And then an order comes out that says, well, for these reasons, this is what the law is. And I can't do what I maybe, we discussed, but here's what the answer is. And it's not in Garcia's favor.
Yeah, she has suggested as much in some of her comments.
Yeah.
And almost like, taking these things under advisement, pushing these things off is just a way she is, running a stalling game here to some degree, because she knows, if she thought she had the authority to grant Abrego Garcia relief that they want, she'd have done it by now.
She would have done it already. I agree.
And she's stalling, knowing that at the end of the day, I mean, she came out, as Margot said, she came out and acknowledged that it's pretty much black letter law that she cannot make a determination of where ICE detains him. If he's detained on the criminal charges, that's going to be in Tennessee. If he's going to be detained by ICE pending removal, it's black letter law that she can't affect that. She can't change that. There's no
right. And I don't see this judge as some of the others where, like, oh, she's going to do it anyway. This judge is not like that.
But do
you think
part of what Margot
waiting to
Go ahead, Margot
was pointing out in her refusal to believe anything DOJ says is she keeps asking them point blank, what are you going to do? And they keep, if he goes into ICE custody, what are you going to do? And they keep telling her, well, we'll decide after he goes in. And she says, I don't believe you. I don't believe that you haven't already decided.
Right.
But I can.
Well, and that may or may not be, but they don't really have to tell her. On the other hand, Steve and I were discussing this over dinner tonight. The government, I don't think, would even be jumping through all these hoops, producing this witness from the immigration section to discuss this, doing this hearing, which they maybe didn't even need to do either, if they didn't have the problem that they already once wrongfully shipped this guy to El Salvador. So, they have to maybe do a little more explaining in this particular case. Because what do you guys think of this? I can't see them going through all of these hoops and doing all of this in any other case where they hadn't made this big screw up to start with.
Well,
go ahead, Margaret.
No, because it's talking about the authority of a judge. And as much as she can say the government's being disingenuous, it's none of her business in this case. So I could see the government standing on its position in any other case where the judge is going so far out of bounds on immigration law, which is what's happening right now. District judges are not supposed to be involved in this, and we're seeing more and more lawsuits filed. One of the things I was going to say was I have a feeling she is delaying it, and she's hoping the district court denies bail or release.
And then she doesn't have to worry about it. I wondered that too. Yeah.
And that the district judge might realize she's taking this under advisement. I listened to her, or I saw what she was saying. I'm going to save her. Judges sometimes do that. Sometimes they make each other's life easier. And the district judge probably figures that this actually is not really going to hurt Garcia because he's not going to South Sudan, and we don't have to get into more issues, and I'll just decide it that way.
Steve and I call this the Black Robe Protection League, right? Where they kind of do things to help one another out.
I wouldn't be surprised if the clerks between the two chambers aren't talking to each other.
That's why I thought it was so interesting that the papers in Tennessee don't show any whiff of that at all.
Well, no, I'm not talking about the federal defender's office. I'm talking about clerks between the two judges.
Right. No, that's what I'm saying. But it's interesting to me that the pleadings then in Tennessee, they're not talking about this Maryland case. It's like it doesn't even exist really.
Oh yeah,
Yeah.
They know.
Yeah, exactly. Yeah.
Yeah, I said this last week when we talked about this. I think on Monday or Tuesday. I'll say it for Margot's benefit. I honestly think that the government. She says, I don't believe you haven't decided. If I'm in the decision-making role at DOJ, my point of view might say, I'm not going to decide because I don't want that judge to be able to interrogate me on what my decision is.
Right.
She's out of her lane, so I'm not going to decide, and I'm going to keep telling her I haven't decided.
Right, because I haven't, because I'm not letting myself decide, because then you get to ask me a bunch of questions about it.
Right. So you do what you're going to do, and once you do what you're going to do, then we'll decide what we're going to do.
Right.
Okay. And as I've said, I think the ultimate outcome here is they'll tell Abrego Garcia, you choose where you want to go. You want to go to El Salvador, we'll send you to El Salvador. If you don't want to go to El Salvador, South Sudan's the other option. Baltimore is not on the table.
I thought that stipulation was kind of also a not so subtle hint to his lawyers of the same thing, right?
Yep.
Like, if you want to reopen this guy's case and put El Salvador back on the table, then, give us a call.
Right. But I think they still hold out hope that Judge Zenas is going to rescue them. Or
his lawyers obviously do, and that's not going to happen, I don't think, actually.
Yeah. Or maybe the ace, up their sleeve is, we'll just roll over on detention in Tennessee.
Yeah.
We'll withdraw.
Right, because they could play that card, but then they're faced with this problem that I alluded to earlier, which is ethically, how can you do that?
How could the judges do it? The judges have already ruled the Bail Reform Act is not appropriate.
Right, in that case, yeah. So, okay. Well, let's switch then to a couple of other topics that we wanted to cover tonight. The first of which is the one we were going to brief last week. And then, it was like drinking from a fire hose last week and this week with all these legal cases of interest to the right. So we were going to talk last week about the P. Diddy verdict and where that's going on a sentencing basis. But Ship, I wanted to do that with you on the line.
And to say good night.
Yeah. All right. Well, thank you, Margot.
Thanks.
As always, we love having you here. Thank you. So, Ship, I wanted to talk to the folks about this with you on the line because it can get a little wonky with the sentencing guidelines in this case. So, but one thing I was telling people online was, why did this verdict come out the way that it did in Diddy's case in federal court? Because he was tried in federal court, not state court. Now, Margot, you're welcome to stay if you want to. You don't have to sign off. Ship, what was your reaction? Let's start with that, to the verdict generally.
Okay, it's pretty straightforward. Okay, the case was never about what the public perception thought the case was about.
Right.
You could see from the time it was filed, all the commentary leading up to the trial. We're going to have, the celebrities having sex parties with, minors in, the backyards of Diddy mansions in Los Angeles and Miami. It was not that. It was never going to be that. Just the fact that they called it a RICO case didn't mean that, everything under the sun in terms of, the commentary about him and his activities for 3 decades was coming into the case. The case was almost exclusively built upon the allegations in a civil complaint filed in November 2023 by the
The
primary victim.
Yeah.
She filed a civil complaint. He ended up paying her $20 million to make it go away. She asked for $20 million before she was going to file. He said no, so she filed. The allegations, it was a very lengthy civil complaint with lots of details, and they lined up almost exactly with what the criminal case ended up being. And then you had the second victim come forward that I don't know as much about, but there's a long passage in time before the events involving the second victim that became, the 2 counts of sex trafficking and the 2 counts of Mann Act violations, one for each of the 2 victims who were the primary focus of the case. No question, absolutely no question that this conduct happened. Was never a part of the defense. Was never, I didn't do it, was never part of the defense.
And I didn't think there was any question that it violated the Mann Act either. Did you?
I don't think it violated the Mann Act as to the victims. It violated the Mann Act as to the sex workers.
Well,
they're the ones that were paid and flown cross country.
yes, that's my point. Because under the Mann Act, the victims, and including the sex workers, aren't really male or female, aren't considered participants in the crime. They're considered victims of the crime. But it's illegal under the Mann Act to pay prostitutes to cross state lines. You boil it down.
Right.
So there was no question that's what happened, right?
Well, yeah, but in terms of how you end up with a not guilty verdict, the issue on the 2 sex trafficking counts, the more serious counts, came down to purely a question of consent. You don't have sex trafficking if the participants are willing participants, if you have consent. And that was the focus of the defense, is that, regardless of how much debauchery went on and the nature of the abusiveness of the relationship, if you have consent, you don't have sex trafficking.
Right. There's no law against debauchery in this country.
Right.
Not anymore. Okay. So for people who don't know, so Diddy was found not guilty of the racketeering and of the more serious sex trafficking, but he was found guilty of 2 counts of the Mann Act, statute, which is transporting prostitutes across state lines. So that's what the case really, factually, that's all it was worth. That's all it was ever going to be worth.
That's all the jury accepted. The jury heard extensive testimony from both victims and heard corroborating testimony from multiple sources. And at the end of the day, the jury's verdict can only be explained on the basis that they decided it was, not coerced. It was voluntary. It was consensual conduct. And, there was a long history of communications between multiple parties that you could, and you could come to the conclusion that the government did not prove beyond a reasonable doubt that it was coerced.
Right.
That there was enough doubt as to the nature of the relationship and how the victim's participation in the events was obtained, that, a guilty verdict beyond a reasonable doubt, 12-0, was not in the cards.
Right. So why, if it was so clear, because it was crystal clear to me that they weren't going to get a conviction on that RICO charge, and almost as sure I was they weren't going to get a conviction on the coercion counts, why did they charge those?
I actually think they were playing for a plea to 1 sex trafficking count for the main victim. I'm sure that was offered. Drop the RICO, drop, everything else, take 1 count. I don't think they would have offered a plea to just the Mann Act violations. That would have violated
their policy would prevent them from doing that, right?
That would have violated a lot of DOJ policies about taking a guilty plea to a lesser offense while dismissing the more serious offenses.
Right.
But this case was only filed in May of 2024. Relatively quickly got to trial in a year, given the nature of the case.
Yeah.
But I think part of that was that the allegations of the case were relatively streamlined based upon the reading of the indictment, and they were never materially changed or expanded. It wasn't a case where And this is what I think a lot of people expected is, well, this is just the starting point. If we don't get a quick disposition with a guilty plea, they're going to bring in everything else. They're going to bring in all the parties and all the celebrities, and Justin Bieber will testify, and and it's just that is a Jeffrey Epstein story.
Right. Yeah, which we're not going to talk about Epstein. But the other thing to me was, a lot of times this kind of sex stuff is not in federal court. For one thing, the federal judges hate it. They hate these cases with a passion. They don't want all of that salacious bullshit in their pristine, rarefied air federal district court courtrooms. And I can't really blame them in a way, but it smacks to me of the kind of case where the feds decided they had to do something. The public outcry was great on behalf of these women who, yes, he's evil, right? He's awful. He's an abuser, no doubt about that. But, the state wasn't going to do anything, didn't do anything. And to me, this is when you have a federal criminal case, you end up with acquittals in whole or in part, where it probably shouldn't be in the federal court, but they bring it anyway because we quote unquote have to do something.
Right, state of California, I think part of it was only the feds have the power to take on somebody like him because look at how many times he had paid money or arranged for evidence to disappear or intimidated witnesses and gotten away with it.
Right, exactly. What were you going to say, King?
Given how narrow the case was presented compared to RICO charges, do you think it was overcharged with that RICO count? I never saw anything closely resembling a RICO case. I wonder if Margot's still on. I wonder if her former professor Blakely, who invented RICO,
Yeah.
Whether he ever imagined that that law would turn into a enforcer against Hollywood sex
Debauchery.
debauchery.
Yeah. Well, as I said, for my part, I'll say I thought that case was a Mann Act case on its best day. Like, I think the jury got it right. The rest of that stuff was overcharged. Margot, are you still there? She's still on, but I don't know if she's still listening to us, you guys.
But that's my view. I think it was, without
Now,
more, it's grossly overcharged.
I could have seen going down the RICO path if you were going to have other kinds of crimes. You're going to have extortion here or arson there, or you're going to make
bribes.
You're going to put in 10 predicate acts.
Yeah.
Beyond just these two victims in two different kinds of sex charges. That's a RICO case. That's Sean Combs using his wealth and his organization for criminal purposes.
Yeah, like intimidating witnesses, tying them up and threatening them with
threatening their
death
families.
if they tell anybody, and bribing people to be silent, that sort of thing.
And they put in a lot of evidence of that, but they didn't charge those as predicate acts. And you have Vicar, violence in aid of racketeering, that they didn't make any effort to use. Even though there's the one obvious episode about the guy, the rival, having his Corvette or Porsche or whatever it was firebombed. The hole being cut in the roof and a Molotov cocktail dropped inside.
Yeah.
Now, but let's turn to something you raised, and that was, when there was an effort for, bail pending sentencing, the two sides submitted their respective views on what the possible sentencing parameters were going to be. And, their government has latched on to some enhancements that might very well apply to take what is otherwise a relatively modest 15 to 21 month sentencing range for just the Mann Act violation up into the 50s or 60s.
Yeah. So let me tell people a few things about this. So I actually handled the Mann Act case, took that case to trial. years ago. So I've done the sentencing on this charge, and relatively speaking, it's a high base offense level. So you start from a pretty high level. So it's not like false statements or FARA or a lot of the white collar stuff where you start maybe at level 6, right? For Mann Act, you start at 14, and 14 is in the part of the sentencing chart where that you're going to jail. And since you went to trial and didn't plead guilty, you're not getting levels off for that. And then you go up from there if there's more aggravating things. So it's not like a slap on the wrist kind of sentence, even if you just go with the base, right? Ship, are you there?
Yeah, I had to find my phone. Yeah, yes, but it's a little different than the last time you practiced with the First Step Act. Although
Yeah,
there are issues here about violence
right.
that might make the First Step Act inapplicable. But you're right. Level 14, even the calculation for the defense is 15 to 21 months, but they're banking on the fact that he's been in custody for 12. Good times extrapolated. He's probably going to get credit for 14 or 15.
Right. So he
And
was
so
on the
it's
cusp of a certain way of looking at the case with a certain kind of judge. He could have gotten released, right?
right. He would have be close to the number that was likely to be a
The sentence
custodial
anyway.
sentence
Right.
to be imposed. So there is a policy against keeping him in custody longer pending sentencing, because then he would in effect overserve what his likely sentence is to be. Now,
Right.
I think when we get to the question of appeal, there's a chance that he will overserve and he might get bail pending appeal. However, the government's calculation, to me, can be argued for. The government adds, they've got an enhancement for use of violence. They've got an enhancement, 4-level leadership enhancement, which I think is probably appropriate given the scope of the organizational influence. I can't remember. There were a couple others. They had it up in the 50s, 50 to 60
Yeah.
range,
Well,
right?
because they lit upon this very interesting feature of the guidelines when you're talking about these kind of sex crimes, that where they're saying for each victim of the offense, whether or not they were a named victim in a separate charge, but if they were, proved at trial or in the indictment as a victim of the Mann Act offense, that constitutes a separate group. And for sentencing purposes, if something is a group, then those charges are handled together, and then other charges that are of a different character would be a different group. And the basic rule is the more groups you have, the higher the sentence goes, right?
Right. And this was something we ran into a lot in the January 6 cases, because the government would give you an offer to plead to one assault count, and then that assault count would be the only basis for grouping. But if you went to trial and there were actually 3 assault counts involving 3 different officers, they each stacked up separately, and that added levels to your offense.
Right. And what they're saying
Um,
here goes a little beyond this, Ship, where it's not just each victim is in a different count, but that the total number of victims, regardless of count, constitutes separate groups. And I don't think I've ever seen that applied. I don't know if that wasn't in the guidelines, because I tried that Mann Act
yeah.
case more than 10 years ago. But
Yeah, I understand the point you're making, and I'm vaguely familiar with it, but I've never done a sex crime case, so I
right.
wouldn't. It's not something
So
I've
it's
run
like
across.
2 Mann Act counts, but there are like 5 to 7 victims. And so now you've got 5 to 7 groups. That's why the defense lawyers are saying it's 15 months and the government is saying it's 50 months. That's
Okay,
part of
now,
the reason.
but let's add this, because this is the one that really is fascinating to me. The 2 counts in question are separated by how many years? I mean, the first girlfriend, her conduct goes back to 2000. I mean, like 2004 to 2014, right?
Right.
And the second victim was like within 2 or 3 years of the charge. Those are so attenuated in time. That's the basis upon which judges enter consecutive sentences.
Right.
2 distinct episodes of criminality separated by victim and separated by time should be treated with separate sentences.
And the guidelines have like policy explanations for doing it that way.
Yep.
Yeah.
Yep. It's not like it's so the contrary, the opposite would be January 6th, where you pick up 3 assault charges, but they're all for the same 15 seconds of conduct against 3 different officers. That's considered one criminal event with 3 victims. Whereas you're talking about here something that happens with 1 victim, a long passage of time, and something that happens with a second victim, the policy is against treating those as one criminal episode.
And then if you're going to bump it up for, there's not just 2 victims because you have 2 counts, there's 5 victims. And so those are all separate groups. Plus you've got this leadership. So leadership is a separate issue from the RICO. If I were the defense, I would be fighting that. But the theory of it is that if the other people involved in the activity don't even have to be defendants. They don't have to have been convicted for sentencing purposes. It's just if you carried out your criminal offense through like a group of people, even if some of them or a lot of them are unwitting, if you're a leader in this group, then you get even more levels added. Now, I've always thought that quite a few of these provisions in the guidelines were unconstitutional, but nobody's asking me. So, but I was really shocked at the wide divergence between the 2 positions. I bet those defense lawyers were as well, as to where the guidelines calculation comes out.
Right, but my point is that given the nature of the conduct, and this depends on how it lands on the judge.
Yeah.
Given the nature of the conduct, if the judge decides, this is just so egregious and over the top, and I recognize that the jury acquitted you on the sex trafficking charges, but there's a lot of substantial overlap between the sex trafficking and the Mann Act, and so I can consider the evidence involved in the conduct that you were acquitted of because it overlaps with the conduct you were convicted of. And I'm so offended by the way you have conducted yourself for a decade or more. I'm giving you 6 years. And I'm giving you 6 years consecutive on each count.
Right, which would be crazy. That would be a crazy sentence. And I don't expect the judge to do that, but it's not impossible.
This is a crazy case.
Yeah. But then you run into the issue of sentencing. We talked about this before, I think, in the J6 context. Sentencing people on the basis of conduct that they were acquitted of by a jury is very problematic.
Well, in fact, the Sentencing Commission has now modified the guidelines to say that it cannot be considered except where the conduct overlaps counts of acquittal and counts of conviction.
Which is not any different from saying you can't use it if you weren't convicted of it.
That's not necessarily true. That's not necessarily true. I mean, that's if you're acquitted of obstruction and convicted of assault, you can't use the obstruction as part of the assault because they don't have anything to do with each other.
No, but my point is that if the facts overlay both charges, but the jury acquits you of one kind of charge and convicts you of the other, but the facts overlay, then I'm not sure you're actually being sentenced for acquitted conduct, right?
Exactly. Yeah. And that's the point. That's the point I'm making, is that the judge can consider the egregious factual actions.
Which the judge could have always considered anyway, even with the one charge, right? So yeah, I don't have a problem so much with that, but this strikes me as the kind of case where you could go all the way to the Supreme Court on this lunatic case because the judge decides to max him out and use acquitted charge conduct, right? And it's like the Harvey Weinstein case or the Bill Cosby case or the Jussie Smollett case where, the conduct has a huge ick factor, right? But the rules don't allow you to express your outrage at the ickiness, if you're the judge, as much as you wanted to, and the appellate courts have to tell you to do it over again. So.
But again, though, the federal case law is very clear that the judge has the discretion to sentence you right up to the statutory maximum, and he can take into consideration all the mitigating and aggravating facts in reaching that conclusion.
Yeah, but if he wants to go outside the guidelines, he has to explain why, right? And it still has to be a reasonable sentence.
But my point is, there's plenty here to
Yeah.
explain why with.
Yeah. Yeah. Well, people always think so when there's a lot of ick in the situation.
Yeah.
So, right. So,
But that's
yeah,
why
he
that was
could
my
end
point.
up
When I
with a
said
long sentence.
it all depends upon how that evidence landed on the ears of the judge.
Well, and as I said, they hate these cases. They don't want this
Right.
crap in their case for their courtroom.
And that goes back to the other point I made to start with, is this wasn't a case about I didn't do it.
Right.
I got a question. These two women who claim to be victims, are they victims, legally victims to a Mann Act?
No, the sex workers would be the victims, the
That's what I thought.
prostitutes. Yeah.
So how do the sentencing guidelines relating to victims even apply here? Don't you have to look at the sex workers?
Yeah, that's who they're saying. That's who the government is saying are the, because this is
Yeah.
the crazy way the Mann Act works. They're
Yeah.
saying those sex workers were transported across state lines. And from a moral
Okay.
perspective, you may say, well, they're not
Okay.
victims. But from a legal perspective, that's what the
Yeah,
statute
but I
says.
think, King's question is, why does the abusive treatment of the non-victims even factor into it?
But it may not. If the government's taking the position that the sex workers, of which there weren't just two of them, right?
Right.
That's
There were more than two. There was
that's where this
many,
5 to
many.
7 number is coming from.
Right.
Yeah.
Right.
So it
Again,
might,
though, but I still think, yes, King, I understand your point.
yeah.
But there is, in federal sentencing, there's Section 3553A, and one of the factors the court has to take into consideration in 3553A is the background and character of the defendant. And all of this debauchery
Yeah.
is part of the relevant information as to the background and character of the defendant.
Right. In my case, we had a plea offer for a number of months. I won't say what it was, but a number of months. And the client wouldn't plead guilty. And I tried everything I could to get him to take a plea in that case because we were not going to win at trial. His mother begged him to plead guilty. The wife begged him to plead guilty, but he wouldn't do it. And so we went to trial. And as I predicted, we lost. And the judge gave him twice what the government offered us on the plea because they hate these cases. So that judge there is probably also going to be offended. And I agree with you. Maybe he won't go so far as to give him consecutive sentences on the 2 counts, but he's not going to go light on the sentencing guidelines, I don't think.
Well, I think that Diddy is being treated to some extent like Epstein, and in the sense of there's all of this hostility out there about the way Epstein, who was a wealthy guy, was able to escape punishment. And so I think you see some of the same thing with this guy. And I'm no fan of his, but he went to trial. He should have gone to trial because he came off better than he would have through any plea, as I think you said, Ship, in terms of your prediction of how was what the offer was. And at the end of the day, he's a prominent, wealthy guy, maybe a big jerk too. The evidence
Well, that
was
understates it,
yes,
but okay.
may have been pretty clear on that. But in terms of criminal sentencing, the fact that he is debauched is not, in my experience or in my review of the law, a legitimate basis for giving the guy an enhanced sentence. So we'll see what happens. But
I don't disagree, Steve, in a vacuum.
Yeah.
But if you followed the evidence here, it wasn't just his proclivities. It was how he used his power and authority over the lives to force them. Okay, granted, the jury acquitted him. They found consensual conduct here. But he controlled their careers. They were signed to his record label. He could make careers disappear. He could make careers appear. He paid for flew them wherever in the world they wanted to go, beat them when they got there if that's what he felt like he wanted to do. So it wasn't just the actual sexual depravity.
Yeah.
It was how he used his power and authority to get that from them.
Right. But on these kinds of facts, that's still not a criminal offense. It's just not.
There's plenty of wealthy guys that use their power and authority and treat people under them poorly. And I'm not, beating on your woman is appalling to me. But on the other hand, he didn't just beat on the women all the time. As you just discussed, he spent lots of money on them, developed their careers. It was a package deal. There was good and there was bad. But the unfortunate reality is, and it was one of the first things I learned when I was a prosecutor, you'd have all of these women come in who had been beaten up by their boyfriend, and they were pissed and they wanted justice for it. And of course, most of them, the large percentage of them, a week or a month later, wanted to drop charges because they'd made up with their boyfriend.
Now, that was back in the 70s when things were different.
It was 50 years ago. But human nature hasn't changed that. We've made some progress, but not huge progress. My point is simply that there's a lot of guys out there that are jerks and are beating on their women. I don't think that Diddy, in that sense, is unusual. In fact, he's better than a lot, you could say, in some ways, because aside from the sexual perversions and the occasional beatings, he also developed their careers, showered them with expensive gifts, stuff like that. So I'm not saying
this is why the jury didn't think there was coercion. They thought it was kind of like, okay, well, good, bad, and ugly, and you went along with it, and this is what people think. So, as a woman, I find it the whole thing appalling, right? On the other hand, you didn't have to stay with this guy.
No, and now to treat him like he's Al Capone. Now there's some irony because apparently he liked to act like a gangster. But,
Yeah. So, we kind of digress a lot on that point. But so we'll see, right? Is the judge just disgusted? Because that certainly is a possibility. My judge was in the case I had.
But you guys shouldn't have gone to trial, which is part of why the judge smacked it.
Well, that's true. I didn't have as much of a defense as Diddy did. Any more comments on this topic?
No, I agree. I didn't say it earlier. I agree with Steve 1,000% that Epstein and Diddy are stalking horses isn't the right word.
No, but they're kind of linked in the public consciousness. Epstein got away with it. Diddy shouldn't be able to. Yeah.
Right. Well, not just that. They're representative of a boogeyman class that the public is convinced exists.
Right.
And so they're the ones who have to take the beating. Right. On behalf of everybody else who's getting away with it.
Who's similarly situated and is an abusive asshole, because that's clearly the case. But, that's not against the law either. And of course, we're defense lawyers. This is kind of how we see the world. But speaking of abusive assholes, shall we talk about John Brennan for a few minutes? Because he was on our list to discuss too, considering that apparently John Ratcliffe, who I'm liking more and more, has referred John Brennan over to DOJ for potential prosecution and at least investigation. And Ship, you wrote a good Substack about this today. And King, I think you wanted to talk about this too, didn't you?
I do, but I have to run, unfortunately, tonight. If you want to kick it to next week, I can do that better.
Okay.
But I have a lot to say, yes.
All right. So you got a lot to say. We'll kick that to next week because there may be more developments. But the basic bottom line is the DOJ apparently, or FBI, has a case open. Read Ship's Substack on it, and then we will talk about that in more detail next time. The other case that we wanted to talk about that I know Steve wanted to talk about a little bit is this standing order case. So I'm going to give people the update on that. This is the case in Maryland where the district court bench has put in automatic TROs for these immigration habeas cases of 48 hours just by standing order. And at this point, what's going on with that is because all the judges in that bench were sued by DOJ, the case was referred to a judge from the Western District of Virginia, who happens to be a Trump appointed judge. And he has set a hearing on the preliminary injunction that the government has asked for. He set that hearing for August 13th. Thus far, the government has filed a motion for preliminary injunction. Nobody bothered with the TRO. They're going straight to the preliminary injunction. And the judge issued a scheduling order so that the judge's briefs in response to this are due on July 21st. The government can then reply on July 28th. Hearing, as I said, set for August 13th. He also issued an order basically assigning the deputy clerk of the court to act as the clerk of the court in that case because the clerk of the court has been sued by DOJ. So, Steve has written an article about this. It's not been published yet, has it? So once that goes up for publication, I'll let people know where they can find that. But we've talked about the substance of this a couple of times, and I think we'll do that in more depth when the final briefing is due. So, Ship, is there anything else you wanted to say about this case while we're waiting for the briefing?
No, I haven't really looked at it since the last time we talked about it, so I'm going to read what Steve wrote and, wait to see what happens.
Yep. Okay. So let me run down the latest updates because we're almost to the end here of what I want to talk about tonight. So folks have been interested in these two cases in Maryland, that the ones that made it all the way to the Supreme Court from the same judge in Maryland. Not Judge Zenas, but a different judge. So the one is the birthright citizenship case. They have now asked for class action in that case because the Supreme Court said that the universal injunction in that case was not legal. So the plaintiffs have asked for a class action. The government has opposed that, and the plaintiffs, their opposition, government's opposition, was due on Friday. The judge has issued an order saying that the plaintiffs can reply on July 16th. And so that's another one where, okay, this is more briefing on whether there is going to be a class action, whether the judge is going to issue another TRO on a class action basis for the classes, babies that are yet to be born or have recently, that are going to be born and therefore subject to the new executive order when it goes into effect. So we're going to keep an eye on that. And when all that briefing is in, we'll talk about it. Then let me see. There was one more. Oh, Congresswoman MacGyver's case. The judge set a jury trial in that case for November 10th. And at this point, Ship, I think you weren't here last week when we talked about this. There's apparently a lot of audio and video evidence in that case. And so the judge has excluded all of the time up until the middle of August to let the defense review that stuff and file their motions. So we're still in motions practice on that. And then in Judge Dugan's case up in Wisconsin, the judge has said that the magistrate there has recommended against dismissing on the basis of immunity. And this is another case where we're going to do a standalone one night space on this, just about those arguments and break that down in more detail than we have time to do tonight. And the judge has said that the defense has to lodge their objections to that recommendation from the magistrate by the 17th. The government then has 2 weeks, which takes them to the 31st to respond. Then the court is going to set a status after ruling on that. So that case is in progress also. And then the very last thing I have, Ship, you want to comment on this, is As of this evening, Senator Padilla has not yet been indicted for anything in respect to that press conference with Kristi Noem. You want to change your over-under on that?
Oh, I don't think I ever gave an over-under. I think I said I predicted that he would have to be indicted to have some
Comedy.
symmetry with the Representative MacGyver.
Yeah.
Although, the nature of the conduct was such you could rationalize an exercise of prosecutorial discretion as to him, while at the same time recognizing it's certainly chargeable conduct.
Right. But the DOJ hasn't said anything about it. So we're really going to have to work up a matrix, my friends. It's going to have to be like the MacGyver, Dugan, Padilla, Brennan something matrix about when when these folks should be charged and when they shouldn't be,
Well,
according to us.
yeah, the other issue at work there, though, is that, they've got a whole different set of battles on their hands in the Central District of California
Yeah.
with all the ICE stuff. So
They got other things to
that,
do there that are more important. Right.
right, the U.S. attorney there is, very active, and I think they are going to, my prediction there is they are going to continue to be very active, and maybe, okay, here's a hot take. If Judge Breyer finds a posse comitatus act violation and attempts to impose some remedy by way of injunction, President Trump will pull the trigger on the Insurrection Act.
I have been worried about that as well, that just inevitably leads in that direction.
Yep.
Yeah.
You say, yeah, you think so, Judge? Well, let's do this,
Well,
because this statute says there is no judicial review.
right. So I'm going to trump your Trump, and that's how Trump rolls. So, right. I know. So high stakes. Well, I mean, the
Because
DOJ.
he can say, I've got military personnel trying to assist law enforcement, and they're getting shot at.
Right.
Where's your law enforcement?
Right. Right. We can't be having that, which is true. We can't be having that. So, right. There's only so many solutions. Right. But still, that's not a place that I was hoping we would go. But play stupid games, win stupid prizes comes to mind a lot these days. So, all right. Well, have you got anything else you want to?
Well, let me just append one more comment to that.
Okay.
I am in the middle, for appellate reasons, of going back through the case law on the Insurrection Act and seditious conspiracy.
Yep.
Okay. Seditious conspiracy is an agreement to oppose the federal government's effort to enforce the law. Breaking the law is just breaking the law.
Right.
Opposing the federal government's efforts to enforce the law
is something else.
And the foundation
is
something else. And the foundational case on that has to do with efforts to prevent the drafting of soldiers into the Union Army. Okay, an organized effort to prevent soldiers from being, conscripted from their state militias into the Union Army.
You mean during the Civil War?
During the Civil War.
Right.
That's where the seditious conspiracy statute came from.
Yep.
Okay. When you are organizing efforts to prevent ICE from enforcing immigration law, that is seditious conspiracy.
Great.
Not protesting.
Right. Not protesting.
Not protesting.
Right. Yeah.
But when you are engaged in active efforts to stop ICE.
Right. Well, that's why recently,
execution of their duty.
I don't know if you noticed this, but when Karen Bass said on Twitter recently that she'd signed this executive order that the city of LA was going to do things to, what was the verb that she used, to, basically prevent the federal government from carrying out the ICE activities. That's exactly what I That's exactly what I tweeted was, you realize that that's insurrection, right?
Well, and then yesterday there was this big announcement that they were going to provide cash assistance to people impacted by ICE activities, right?
Yeah.
Now, if you're providing cash assistance to an illegal alien, to assist that illegal alien to remain in the United States, that's violation of 8 U.S.C. Section 1324. You cannot assist somebody who's illegal to continue to reside in the United States. It's it's part of the harboring statute. Right. When I went to look at what she actually promised, her lawyers made her understand that the explicit execution of what she was claiming would violate that statute. Because what's actually happening is the city is going to coordinate with nonprofit philanthropic organizations to provide debit cards with several $100s, which will not be funded by taxpayer money, but will come from, foundations and grants.
Right. Although, isn't that the name of this account is escaping me? We both follow her. Who the gal who does the real deep data dives on stuff? Wasn't she? Do you
Small
remember?
Republican or Republican data,
Yes.
or whatever.
Yes. I apologize for not knowing your handle well enough. But wasn't she saying that some of the groups that were going to be doing these philanthropic efforts had received grants from the
they've got
state of
grant money
California?
from the state of California. CERCLA, that's the name of the primary beneficiary that's received like $34 million from the state of California. And yes,
Well, how is it not
they're in
tax
it.
dollars?
Well, because that is, but it's being funded. It's being cycled through an NGO. So yes, its original source is tax dollars. But the point being made is that the city of Los Angeles is not putting money on these debit cards, and the city of Los Angeles is not handing out these debit cards. They are being handed out by NGOs with grant funds, even though that's not the way it was trumpeted in the media.
Right. And Karen is taking credit for it. That's what basically what's happening.
But I think if her lawyers told her, yeah, we can send out debit cards with our money, she'd probably say, let's do that. But they told her, no, you can't do that. Maybe we can do this.
Maybe we can do this instead. Right. So, yeah. Okay. Oh, she was going to protect the citizens of LA from the federal government. That was the language in her tweet.
But that's just
wow.
Figurative. That's figurative.
Figurative. It's figurative insurrection? Oh, okay. Oh, my God. All right. Well, I think that's all the news from Gary Gnews, or that's fit to print, or both, for tonight.
All right. Time to go.
So, yeah. I will talk to you later. Good night, everyone.